answers to those questions. And the answers.
Yes, yes. I'll fit it to whatever sounds nice.
Well, welcome. I'm Tim Thompson, part of the Education Committee, and we're glad to have Jim Gilbert here today, and we'll go over that in just a bit. Just a reminder, this is a hybrid class, and there's about 35 folks here at RVAR, and the rest are in Zoom. Laura Benjamin is joining us from her office so that she can monitor those with questions from Zoom. And for those of you in Zoom, please remain muted until a time when you can want to pose a question. There will be times during the presentation where we will ask for questions. For those of you in Zoom, you can either type something in the Zoom chat, which Laura is monitoring, or unmute yourself and ask the question. We will also recognize those in the room for questions. We are recording today's class, and we'll make the recording available for at least 30 days. We'll be sending a survey to the attendees for today's class. Not only do we want your input on today's class, but we will also seek some suggestions for future classes. Before we start, let me mention several upcoming events. The Technology Committee is offering a class titled RPR, Your Best Mobile Friend, on Tuesday, September 26th at 11 a.m. Instructor is Jay Kilby, and he swears that RPR will become your favorite real estate app. The Technology Committee is offering another class titled Social Media Marketing, More Success Stories. Hal and Chris Cohn will demonstrate how they use video in social media marketing, and Heather Watson will demonstrate the use of Reels. This class will be held Wednesday, October 11th at 11 a.m. And RVAR's fall tailgate party and cornhole tournament will be held Thursday, October 12th, beginning at 5 p.m. Come and enjoy the barbecue from Three Little Pigs and a bourbon tasting. Registration for these classes and events is available on RVAR's website. Flyers are available for those attending today's class in person in the back of the room. And now for today's class, let me introduce today's speaker, Jim Gilbert. Jim has been practicing law at Smith Mountain Lakes since 1995. He is a graduate of Roanoke College and then from T.C. Williams School of Law at the University of Richmond. And he has been recognized for his focus on real estate law. In addition to his law firm, Gilbert Law, Jim is also a partner in Elite Title of Virginia, a settlement company located at the lake. Also Impact Title here in Salem, and First Virginia Title Services, a regional company handling title exam services throughout Southwest Virginia. I believe we are going to now turn it over to Jim, and any questions that will be asked, we'll have a time later on for the questions. Thank you.
Thank you. A little bit more about myself first, and then we'll talk about the subject matter today, which is this 50 Shades of POA, which I would love to have taken credit for that title. I did not come up with that one, but when I just realized that that was the title of the class this morning, it got me more excited to talk about a very boring subject matter. So there we are. And so I'll talk some about property owners associations. The real focus where I was asked to focus on was this Resale Disclosure Act that just came about here recently in the last, I guess, 2 months. And so I've got a little PowerPoint to go through that Resale Disclosure Act, and we'll talk about that. Hopefully I can give you a few war stories in regards to property owners associations, to at least make it a little bit interesting. But again, first, a little bit about myself. I've been practicing since March of '95. And so next year we'll be going into 29 years. I started off with a very small firm in Rocky Mount, and that law firm that I worked for in Rocky Mount, we focused on basically a lot of real estate transactions and, believe it or not, personal injury defense. My first boss, a guy by the name of Dusty Rhodes, he did a lot of car accident cases. The insurance companies hired him to represent their folks that had caused these accidents. And so my first 2 years, I got quite a bit of litigation experience and also real estate transactional experience. And then when I went out on my own a couple of years later in 1997, I started combining those two things. As everybody could probably remember, from about 97, 98 timeframe through about 2006, 7 timeframe, that 10-year period, the real estate was going gangbusters like it has been here recently. And so there was a lot of real estate transactional work that I was involved with for that 10-year period. And then when the wheels came off the bus, we sort of transitioned and started doing a lot of litigation work. It just kind of went hand in hand for me because I had that experience on both sides of that table. Starting in 2010, I partnered with a couple of other attorneys, and we built a law firm called GBSR Attorneys that we had our practice at the lake. We had an office here in downtown Roanoke on Jefferson, and also an office in Salem. And then a couple of years ago, I decided I was going to go back out on my own and do a solo practice. I was getting with some of the lake realtors that I know that my grand idea was I was going to slow it down a little bit. And that didn't pan out that way. It has been just like a locomotive freight train going down the tracks for the last couple of years. And I mean, it's amazing how much volume we've had in my practice. So I'm very happy with that. A good bit of that volume deals with real estate, and a good bit of the real estate deals with property owners associations. I was very fortunate to have a case back in 2005-06 timeframe that came out of Bedford County. It involved short-term rental of real estate and whether or not a certain restrictive covenant that restricted the property to residential use only, whether short-term rental of real estate violated that restrictive covenant. And that case, we were successful in an appeal to the Supreme Court of Virginia, and I won the case at the Supreme Court level. The flip side of that is to appeal a case to the Supreme Court, you had to lose it in the trial court, which I did. But we got it appealed, and that was kind of the beginning of my experience with property owners associations and how they work. And there for a while, I represented some property owners associations at the lake. I came to the quick realization that shortly thereafter that I was probably better suited representing homeowners against property owners associations that got out of control. And so my focus the last many, many years has been representing the individual homeowner against an association that maybe is misunderstanding what the rules are or misunderstanding what their authority is. And so with property owners associations, when I do get a request from someone to help them with their property owners association, generally I refer them to a colleague of mine, good buddy of mine, actually, Steve Moriarty with Chadwick, Washington, out of Northern Virginia. They got an office down here in Salem as well. And so I refer a lot of POA work to those guys because I'm usually on the other side of cases from him. So with that said, my perspective on property owners associations is that I'm usually focusing on one little thing maybe that they're doing that isn't, that either don't have the authority to do, they can't do for some reason. And so I usually get to become an expert on like these really little, minutia issues. Whereas an overall common interest community or POA, all the regulatory stuff that goes with that, I'm not as, I would not say I'm the expert on that. I usually let that stuff go over to a law firm that, like I said, Chadwick Washington, that does tons of stuff for property owners associations. But with that said, I've looked at the Resale Disclosure Act. I've got a PowerPoint I'm going to go through with you, and we're going to talk a little bit about the disclosures that need to be made. Some of the statutes, are interestingly worded. I know like there's one issue that we're going to talk about here in a little bit that we'll probably get a question about whether the disclosures can be waived. So we'll talk about that a little bit as well. I'm going to pull up, share screen, and let's start here. We'll do this. There we go. Did it work?
Yeah.
Excellent. All right. I usually have my paralegal here to make all this stuff work for me. And she's not here today. But anyway, so the 50 Shades of Gray is there probably are 50 Shades of Gray in this Disclosure Act. Okay. Keep in mind, when the General Assembly passes a new set of laws, what we call an act, and it's in this case the Resale Disclosure Act, they have folks that help those guys write these statutes, and they go through a process where they write the statute, they do edits to it, they'll go through it, and then they finally, they're getting to a point where they got to pass it, and they get it through. A lot of times what will happen is just like anything else. It's, humans are doing it, so there's some human error involved, and they might miss a word, or they might not have thought about an issue all the way through. And because of that, what happens is that, as I think it's probably a simple concept, is that you ultimately end up with a case that comes out of one of these statutes that goes to court, and then the judges start interpreting the statutes, and until you have some court cases that come out of these particular sets of laws, the ambiguous gray area questions are hard to answer, because we don't know what a judge is going to say in one situation or another. So all I can tell you is, as we go through these statutes, I'll give you my opinion of what I think some of them are intended to do or say. There is definitely room for interpretation of some of these statutes, and I'm sure that different people will have different opinions about them until we get some case law going, working on them, or according to what I understand is that the General Assembly may modify some of these statutes next year to clarify some language. But with that said, Virginia Resale Disclosure Act is found in Virginia Code 55.1-2307 through 2317. And this act was the General Assembly's attempt to combine, as you know, combine some of the disclosures that are required when you have a residential property that is in a property owners association, or in one of the condominium that's subject to the Virginia Condominium Act, and a couple other acts. But mainly the focus that I'm going to take is, as I talk, you'll probably hear me talk about residential properties and residential neighborhoods that are subject to the Property Owners Association Act, because that's, to be honest with you, what I'm most familiar with. Okay. So previously, as you know, if you had a property that was in a Property Owners Association Act, you would go to the homeowners association, you'd get them to give you the disclosure packet that contained all the different things that were in the statute, like, their bylaws, if they have restrictive covenants, or their declaration that would be included, their budget, all that stuff. And then if you had a condo, you would go ask for what they called it the resale certificate. This act is an attempt to, I think, streamline all of those disclosures into one streamlined methodology of getting the disclosures out to purchasers. Okay, so they just have combined all this stuff into this act. And the act has 11 different statutes in it. You got a definitions statute. The 2308 is the disclosures. And basically you'll see that's the statute that requires the disclosures. 2309 is how you deliver them to the purchaser. 2310 is the form that is supposed to be online. My understanding is it's online. The CIC is putting it together. The CIC board is putting it together. And then the statute tells you not only to use the form that the CIC board is putting together, but then also there's like 30 things in the statute that are supposed to be in the packet. Okay. 2311 talks about updated resale certificates. 2312 is important because, and we'll talk about how purchasers can cancel a contract if they get that disclosure and they want to cancel it. 2313 is a liability statute, and it talks about what happens if there's something wrong in the packet and who's liable. 2314 is one where we're going to talk a little bit about that one, because that one is probably got some open room for discussion as to whether the process can be waived or not. And I don't know that it's completely clear, but there's different opinions about it. 2315 talks about properties that are subject to more than one declaration. So if you're selling a property, for instance, like at Mariner's Landing at Smith Mountain Lake, they've got different sections of Mariner's Landing. They have an overall, or at least they used to have an overall property owners association, and they had separate little ones. And then 2316 talks about resale certificates and fees, and 2317 are the exemptions to the act. And so the first thing I want to focus on is what is the disclosures, when is the disclosure required? Okay. The statute says, unless exempt pursuant to 2317, any contract for the resale of a unit, and I'm going to have to move this there, in a common interest community shall disclose that the unit is located in a common interest community. That's already understand in the new RVAR form, that the seller is required to obtain from the association a resale certificate and provide it to the purchaser. Number two. Number three, the purchaser's right to cancel the contract pursuant to the statute. Number four, that the purchaser may request an updated resale certificate. And number five, that the purchaser's right to receive the resale certificate and the right to cancel the contract are waived conclusively if not exercised before settlement. Okay, so the way I interpret that part of that statute, that last part of that statute is if these disclosures are required and you got a property that is in a common interest community and the disclosure is required, but the purchaser doesn't receive the resale certificate and then they go ahead and get closed, then that basically says that they've that the right to receive it's waived. So just keep in mind that if you're representing a purchaser that, and you find out that there is a homeowners association that is in a common interest community, make sure that you go through the process and get them that homeowners packet, because I can't tell you how many times I have had folks come in my office and they say, well, this wasn't disclosed. I didn't get the packet. I didn't get this, or I didn't get that. And I would think nothing worse for any of you guys as a real estate agent to have an upset purchaser who closed on something and they didn't realize that there wasn't even was an association in the first place. I've had that happen. Okay. Little interesting story about that. So I decided I was going to buy a house on the lake here recently, about a year and a half ago. I did. And I did the research because I didn't want to be in a community that had a property owners association that was subject to the Property Owners Association Act. So I did all my research for myself, and we bought the house, and we are there literally on day one, getting ready to start renovating the house. And gentleman, awesome guy next door, who I've become friends with, walks in and he goes, "I'm here to get the $16 for the association, the assessment that we have." And I'm like, wait a second, I did the research myself. There isn't an association. Turns out it was basically just like a very informal fund for our no wake buoy. So I gave him $20, and we went on, and we were all happy. But the other important part of this statute is that the very bottom part is, if the contract does not contain the disclosures required by this section, the purchaser's sole remedy is to cancel the contract prior to settlement. So if you get into a situation where you have a buyer that's buying a property in a subdivision that has one of these associations, and the disclosures aren't in your contract, which I can't imagine that would be the problem, because you're going to have be using the standard RVAR contract. But in the situation where you don't have the standard RVAR contract for some reason, maybe there's an attorney that has drafted the contract, or maybe your client wants to use a certain form for some reason. Okay. Make sure that these disclosures are in the contract, because again, your purchaser's sole remedy is to cancel the contract according to the statute, notwithstanding the fact that if you find out late in the game that there is an association and the disclosures were required and they're not happy, like I would have not been happy that I found out there was an association, they may have already spent some money, as you know, getting ready to move forward to closing. They may have already had bank fees, appraisal fees, home inspections. I mean, they may have already spent some money. They may already even have a truck full of furniture coming, down this way from somewhere else. So the statute clearly states that if you find out that there's an association and it wasn't disclosed in the contract, their sole remedy is to just cancel the contract. So they're not going to get their money back. There's no damages. There's nothing. This is pretty clear. So be very, very careful about it. I can't reiterate how important it is to find out on the front end if what you're helping your purchaser buy is in one of these associations. Okay. Let's see. Let's go to the next slide. All right. Question can be asked: how do I know if a community is a common interest community under the Resale Disclosure Act? So there's some definitions here that are important. These are not all of the definitions. These are the three that I think are important for discussion purposes today. Is that, and the first one's really important. What is an association? For purposes of this act, an association is an association created pursuant to the Property Owners Association Act, the Virginia Condominium Act, Virginia Real Estate Cooperative Act, or a council of co-owners created pursuant to the Horizontal Property Act. The one I'm going to focus on is the Property Owners Association Act, because I think that comes up more often when we're dealing with single-family residential. And so one thing I'm going to tell you that believe it or not many people know, not many lawyers don't even know this, is not every association is an association under the Property Owners Association Act. And I would, without having actual statistics in front of me, I'm just talking from experience, at Smith Mountain Lake, you would think there's lots of property owners associations that are subject to the POA Act. There's actually not that many. Okay, like for instance, I'll give you some examples. Water's Edge, the kind of almost what I would think of as one of the more preeminent communities at Smith Mountain Lake, is not subject to the Property Owners Association Act. Okay, Waterford over in Bedford is another one that has a declaration. They have an architectural review committee. Again, it's not subject to the Property Owners Association Act. And I'm going to explain to you how to know the difference here in just a minute. Okay, so keep in mind, in order for the Resale Disclosure Act to apply, you have to have an association that's subject to the Property Owners Association Act or the Virginia Condominium Act. That's when the CIC comes into play, because the CIC says that it means a condominium created pursuant to the Virginia Condominium Act, any of these other acts, and then the Property Owners Association Act. So the only time the Resale Disclosure Act applies is if you have an association, number one, and the association is subject to one of these acts. Okay, so if you have a subdivision where it's called John Doe, subdivision, and they have the John Doe Road Maintenance Association, okay, it may not be subject to this act. Or let's say with my subdivision, Twin Chimneys, we have the Twin Chimneys Association. We collect money and it's voluntary because there's nothing that requires us to do it. We all just pitch in, and it's to maintain the no wake buoy and the two chimneys down there in the cul-de-sac. Okay, but it's not an association subject to the Property Owners Association Act. And here's how you tell the difference. Okay, of course, here's my slide that I got ahead of it. Are all residential properties subject to the RDA? No. Okay, so how am I supposed to know if a home is an association that is, if a home is in an association that is subject to the POAA? Why are these definitions important? Because not every association is an association regulated by the Virginia POA, Property Owners Association Act. What the Property Owners Association Act says is that in order for a development to be within the POA Act, it has to be subject to a declaration. So we have this declaration that's recorded. Usually what you see in the declarations is it'll set out restrictive covenants. Some of them will talk about a homeowners association. Okay, keep in mind, even if your declaration talks about a homeowners association, it still might not fall within the Property Owners Association Act, and I'll tell you why. Because there's the statute that says any instrument, the definition of a declaration for purposes of the POA Act is any instrument, however denominated, however titled, whatever they call it, whether they call it a declaration or they call it anything else. And by the way, I see folks taking pictures of this. You're welcome to take pictures of all this. You're also welcome to get my email, and I'll send you the PowerPoint by email if you'd like me to do. Okay. So the statute says that you have this declaration, and it has to use, and look at the wording that I've highlighted in red. The declaration has to be recorded in the county or city in which the development or any part of such development is located, that either one imposes, and that's a strong word, imposes on the association maintenance or operational responsibilities for common area. Okay, so you have to have a declaration. It has to have language in it that talks about common areas, and it has to impose upon the association the responsibility to take care of the common areas. So there is this line of cases that came out of the Virginia Supreme Court, at the same time that I was doing Walker versus Scott, the short-term rental case. And then I went back up on a couple other cases to the Supreme Court of Virginia. But there was this line of cases that came out where the Supreme Court of Virginia interpreted this exact language. And this is what the Supreme Court even recently said. This line of cases started 2007 and they ended it. The last one that they wrote an opinion on came out in 2017, Shepard versus Conti. And the Supreme Court, in interpreting this code section, says a declaration must both impose responsibilities and authorize assessments before an entity qualifies as a property owners association as defined in that code section. These elements must be fulfilled by language expressly stated in the declaration. Okay. So you remember I was talking about we have these statutes, these new statutes, and then we have court interpretation of statutes. Okay. So let's look at 55-1-1800, and it says, I'm reading it just like you're reading it. Okay. It says 1, imposes on the association maintenance or operation responsibilities for the common area, or 2, creates the authority in the association to impose on lots mandatory payment of money. Okay. That word between 1 and 2 is or, is what I'm seeing, right? The Supreme Court of Virginia, over from 2007 through 2017, in this line of cases called Dogwood Valley Citizens Association, ending with Shepard versus Conti, they interpret or to be and. Because look at what they say. A declaration must both impose responsibilities and authorize assessments before an entity qualifies as defined in that code section. These elements must be fulfilled by language expressly stated in the declaration. So when you look at the declaration, okay, it has to talk about a homeowners association. It has to talk about common areas. It has to impose upon the association the responsibility to take care of the common areas. And there is a case that was out there back in the mid-2000s, late 2000s, I should say, where, again, the Supreme Court interprets the word impose. And what they basically say is the declaration can't say, hey, association, from time to time, you can collect some money. And if you want to, you can fix the common areas. If you don't want to, that's fine. You know, because I've seen that type of language in it. Okay. That language isn't strong enough for purposes of bringing an association under the POAA, which would then bring it under the CIC's Real Estate Disclosure Act. Okay. So you have to have this language in the Declaration of Restrictive Covenants for any of this stuff to apply. Okay. In a moment, we're going to talk about, when I get to the end of the presentation, the natural question should be in your minds is, if the association that is in this subdivision is not subject to POAA, how do I get my people the stuff they got to look at? And if they don't like the restrictive covenants for some reason or another, the statute doesn't apply that gives them the right to cancel because they're not under the Resale Disclosure Act. What do I do to protect my people? Okay. And we're going to talk about that here in just a minute at the end of the, I'll cover that at the end of the presentation, but just keep in mind that this is a little tricky because it's even tricky for lawyers. Okay. I've had probably at least, I've tried 10 or 11 cases, I think, on this exact issue in Bedford County, Franklin County, and Pittsylvania County, the 3 main counties around Smith Mountain Lake. And all of the judges have agreed with me on this. Judge Updike, Judge Moreau over in Chatham, and before Judge Allen, it was Judge Perdue, and then before that, Judge Alexander. And they've all agreed with me on my interpretation of this, okay? Mainly because the Supreme Court said they had to. So if you get the declaration, okay, and you see that it has all this language in it that's supposed to be in it, and you realize that it is a property owners association subject to the Property Owners Association Act, which then brings it under the Resale Disclosure Act, okay, then there's some exemptions, okay, that you have to be mindful of. Okay? It's kind of, when we go to law school, they teach you the very first week of law school, okay, we're going to teach you all these general rules. And then we're going to teach you exceptions to the rules. And then keep in mind, there's exceptions to the exceptions, okay? And that's your first day of law school, and that's when it gets really confusing. But there's some exemptions to the Resale Disclosure Act. So if we correctly determine that the property that we're dealing with in our transaction is part of the Resale Disclosure Act, and the Resale Disclosure Act applies, then the Resale Disclosure Act says in 2317 that you're exempt from having to do the disclosures if, number one, it's an initial disposition of the property by a declarant. So we've got a brand new subdivision where it's the first sale of the property, okay? A disposition of a unit by gift. Okay, so I am giving the property to my son. Okay, I don't have to in a contract have these disclosures. Disposition of a unit pursuant to a court order if the court so directs. So if we are in litigation and the court directs that this property be conveyed to the other party, and the court directs that they enter into a contract, and the court needs to keep in mind that there's these disclosures that might need to be made, and the court can say, no, we're not going to do it, okay, for purposes of this transaction. 4, disposition of a unit by foreclosure or deed in lieu of foreclosure. So obviously that was added in so that, you know, these foreclosure sales that I used to go to when I was the only bidder there many years ago, and now there's 27 people that are showing up because they're going to fix and flip it. The foreclosure trustee does not have to provide the purchaser at the foreclosure sale disclosures regarding the association that the property might be in. A5, a disposition of a unit by a sale at auction when the resale certificate was made available as part of the auction package for prospective purchasers prior to the auction. So that, I think, is pretty clear. 6, a disposition of a unit in a common interest community containing no residential units. Makes sense. So those are the exemptions. Again, I'll be happy to send this PowerPoint to anybody who sends me an email, and I'll send it to you and you'll have this. It's also really easy. I mean, to get the Virginia code and read through this actually is not that difficult. You can get the Virginia code online, just type in Virginia code and the whole thing will pop up. You go to 55.1 and find the Property Owners Association Act, and they'll have the Resale Disclosure Act. And this is pretty much just copied and pasted from that. So, but probably easier just to go through my PowerPoint if you send me an email. All right. So who's responsible for getting the disclosures to the purchaser? The statute says that the seller shall be required to obtain the resale certificate from the association and provide such resale certificate to the purchaser. Doesn't say when, right? Just says you got to do it. So in my practice, if I'm representing a seller in a transaction, excuse me, if I'm representing a seller in a transaction, obviously I tell the seller, go get that packet, get it now, get it to the purchaser immediately so that whatever time frame you have in that contract comes and goes. Because the other side of my brain, when I'm dealing with a purchaser, when they come in my office and they go, I don't like something about this property, and whatever their dislike is about the property, and we sit down and we start reviewing the contract, and there's nothing in the contract that protects my purchaser or allows them out. My natural first question is, have you got a copy of that homeowners association packet yet? And sometimes they'll say yes, and you know the time frame has gone by, but sometimes they go, no, I haven't seen it. So of course, first letter that gets sent out of my office is, we'd like a copy of the homeowners association packet, please. And then the day we get it, the next day we cancel the contract. So it can be used as a pretext. So if you're representing the seller, make sure that the seller gets this thing. They're required to now by statute. There's no time frame for it, and at least from what I see, but do it fast if you're representing the seller. If you're representing the purchaser, keep in mind that the longer that time goes, and they decide they don't want the property for some reason, that you can use it as a pretext. Yeah, Glenda.
Oh, so you have to get the package to cancel it using that, or you don't? You have to.
I prefer to get the packet. It's just my preference
Okay.
that my client has received the package so that they can then look at it and we can go, we just don't like something that's in it. That's what I'm not going to tell you that you can't do it the other way. That's just always been my preference. I'd rather have them have the packet in hand and then pursuant to the timeframes in the contract, cancel the contract.
Yeah, I was just basing on that first thing when you said you could cancel anytime before 7.
Yeah, well, I mean, that's
required.
right. So I mean, it's a new statute, newly written. But again, I prefer when I'm working with one of my purchasers and they come to me that, it's usually a real estate agent will send the purchaser to me and they go, they want out of this contract. They don't like the fact that the downstairs door is painted purple, just it's weird stuff sometimes. But if they haven't gotten that packet, then certainly it can be used as a pretext. And I just, if litigation comes out of it, for some reason comes out of that cancellation, I just prefer to be able to put my client on the stand and go, did you get the packet? Yeah. Did you review the packet? Yes. Did you not like something about the packet? Yes, I did not like something about the packet. What was it? And then, usually there's something in there, something about the budget or something about reserves or, there's something, there's gonna be something. So just my preference.
In that case, do they get their earnest money back?
Do they get their earnest money back if they cancel? Yeah, under the statute, they get their deposit back. Yes. And I think under the RVA contract, it specifically says that. Yeah.
So did it change on the POA? So I thought it used to read that the POA, the association itself had to get you the packet within 14 days.
Yeah, and that's a point.
Or just the resale certificate?
No, well, that's a good question because now under 55.1 2309B, okay, it says unless exempt pursuant to 2317, so unless one of the exemptions apply. The association's managing agent, or any third party preparing the resale certificate. Keep in mind, it's all called resale certificate now. Okay.
Oh,
Okay. So there's no distinction between POA packets and condo resale certificates. They're all called resale certificates. Yeah, and I can understand why. So preparing the resale on behalf of the association shall deliver such resale certificate within 14 days after a written request by a seller or seller's agent. So that's what I'm going back to, is that if you're the listing agent and you're representing the seller and, keep in mind, this is a pretext purchasers can use to get out of a contract. If they find something they don't like, I'll tell you where it comes up, really seriously, where it comes up most often is they do an inspection of the property and there's just certain things they don't like in that home inspection, but none of it rises to the level of some type of material defect that you would normally think of, like it's not structural, it's just something they don't like in the inspection. And they haven't gotten the homeowners association packet yet. That's one way for that purchaser to get out of the contract. Okay. So if you're representing the seller, go get that packet. Request it from the association because they've got 14 days to get it to you. So you want that clock to start ticking at the beginning of the transaction, not at the end of it. C says that they can print it, they can send it to you in electronic format, and that the information has to be up to date at the time they send it to you. Kind of obvious stuff there. All right, so what is included in the resale certificate, okay, and the packet? The statute says that the association shall include the completed resale certificate form developed by the Common Interest Community Board pursuant to subdivision 3 with supporting documentation set out in the following order, okay? And there's 30 different things. The resale certificate form, Tim and I were just talking about it. I've not actually read through the whole thing, but you can go onto the CIC board website. they have that form there. That's the form that should be being filled out by the homeowners association or their managing agent. And then in addition to that form, they're supposed to give you up to 30 different things if they have it. So for instance, and I've just kind of highlighted things that I usually look for to make sure that they're in a packet. Copy of the governing documents, which are usually like the articles of incorporation of the association, the bylaws. Those are the operating governing documents. Number 4, a statement of the amount and payment schedules of assessments and any unpaid assessments currently due and payable to the association. Number 7, a statement of the amount and payment schedule of any approved additional or special assessments, a statement of capital expenditures, a statement of amount of reserves. So, again, this is all kind of financial stuff in that order. The most recent balance sheet and income and expense statement is something that you would normally find. The current operating budget, if they have had any judgments rendered against them, any unsatisfied judgments, and keep in mind that that can happen because, again, I've had several cases. I told you I usually represent homeowners against associations, and I have had a couple of cases where we've won, and because the POA Act contains a attorney's fees provision, we get a judgment against the association for the attorney's fees. Okay, I've had that happen recently on a case I had over at the lake. If that judgment's unsatisfied, that would be one thing that should be in that packet. Okay, insurance coverage, any written notices from government agencies. You're going to get the minutes of their board meeting for the last 6 months, any approved or draft minutes from recent meetings. Number 20, a statement of any limitation in the governing documents. And it's called 20 to 30 has some interesting stuff in it. Okay. A statement of any limitation in the governing documents on the number or age of persons who may occupy a unit as a dwelling. So that might be something that if there's a restriction on the number or age of people who can occupy a unit, that might be something your purchasers would be really interested in. If they've got a family of 6 and the unit can only allow 4 people to stay there. 21, a statement setting forth any restriction, limitation, or prohibition on the right of an owner to display the flag of the United States. That's very important to some people. And if there's a restriction that keeps them from being able to do that for some reason, then I would think your purchaser probably wants to know about that. 22, a restriction, limitation, or prohibition on the right of an owner to install or use solar energy collection devices. With the push to green, there's a lot of folks who really want solar. And if for some reason there's a restriction against it, again, it ought to be in that packet. So there's a bunch of stuff like that are in here, like display of political signs, for sale signs, parking or vehicle restrictions, the owner's ability to rent the unit. Okay, so there's a lot of stuff that is in this packet that should be looked at very carefully. Yes, ma'am.
I thought in the state of Virginia, you couldn't restrict solar.
I think there's some legislation on that, and keep in mind that probably what they did with the statute is all of these, those 30 things were things that were in the old Property Owners Association Act when they had the disclosures that were required by the POA Act before they moved it into the Resale Disclosure Act. Mm-hmm. These were all things that were in that POA Act. Okay, and they've been there for a long time. And my guess is what happened was that they cut and paste those 30 things into this new Resale Disclosure Act. And I would almost have to guarantee to you that if there is any legislation out there, and I don't know for sure what the actual restrictions are off the top of my head, but if there are, it very well could be that it was just an oversight and they'll have to fix it. So
my neighbor's getting solar panels, but they had to get a special use permit to even get it approved through the county.
Through the county?
Yeah. I got a letter in there.
Mm-hmm. Keep in mind that, and I always tell folks, this is kind of going a little off subject, but I think it's really important advice is when you're looking, when you have a buyer that comes to you and they say, I want to do such and such with this property. okay? There's always two things that you really need to very importantly look for is you need to go look and see if there's any restrictive covenants that prevent them from using the property a certain way. And then also go look at the county ordinances. They're two different things, okay? A county ordinance might not prevent something that a restrictive covenant prevents. And the restrictive covenants might not prevent something that a county ordinance prevents. So you always need to look at both of those things. Yes, sir.
Laura just mentioned, if you could repeat the question before you give an answer, because people can't hear that question.
Yeah, Phyllis, what was the question? I forget. I just started talking.
I didn't have a question, it was.
Oh, it was the
Yeah, it
solar,
was just
yeah.
that solar panels also, you have to step
Right.
further than just the POA.
Yeah,
because
so-
in the county also, you have to get approval. for that.
Right. It was less of a question, more of kind of just a statement, let's say. And so what Phyllis Johnson was mentioning is that sometimes you have to get approval from a county, even though it might not be something that's in restrictive covenants. So, yeah. All right, so moving on to the purchaser's right to cancellation of a contract by purchaser. Again, this is something that is interesting how they've worded the statute, because it says that the purchaser may cancel the contract within 3 days or up to 7 days if extended by the ratified real estate contract after the ratification date of the contract, if the purchaser receives the resale certificate, whether or not complete pursuant to 2310, or a notice that the resale certificate is unavailable on or before the date that the contract is ratified. And then number 2 is pretty much the same thing. It says within 3 days or up to 7 days if extended by the ratified real estate contract from the date the purchaser receives the resale certificate, whether or not complete pursuant to 55.1 2310, or a notice that the resale certificate is unavailable. So the problem with the statute, the obvious problem, is that it doesn't really say if you can go outside of that 3 to 7 day window. And my understanding is that the RVAR follows the Virginia Association of Realtors stand on this, which is that you can change the 3 to 7 days to, I watched Kit's video where, he talks about you can make it 0 or you can make it 10. And I don't think that his position is wrong on that, but as any good lawyer, I could probably argue both sides of that point. Can you go outside of the 3 to 7 day window? I did some research on the internet. I found that the Northern Virginia Association of Realtors is taking the opposite position, which is stay within the 3 to 7 days. Okay. So as any good lawyer, I could probably argue both sides of this thing because it doesn't say you can't. Okay. But it doesn't say what happens if you do go outside of the 3 to 7 days and how, we deal with that situation. My concern would be that if you went outside of the 3 to 7 day window, let's say you get this packet and your purchaser is wanting out of the contract for one reason or another, and you in your contract, you went out of that 3 to 7 day window, okay, and you put in that blank, they got 10 days, or that, let's just say they put 10 days, okay. My concern if on day 9 the purchaser wants out of the contract, wants to cancel the contract after they've taken 9 days to review the association packet, my concern would be that the seller would go hire a really good plaintiff's attorney and sue for specific performance of the contract and say that that's not a way to get out because the statute specifically says 3 to 7 days. And while the opposite position might be accurate, you might be able to change it from 3 to 7 days. Does anyone really want to risk their client going to court and spending thousands of dollars with guys like me to argue that to a judge who we don't know what decision he's going to make about it because there is no case law on it yet? Yeah, Linda. Yeah.
So if they put 0 in there.
Yeah.
Okay, but they haven't gotten the package, would that not mean they can cancel? Because until they get the package.
Yeah, I mean, it's but you put, let's say you put 0 days in there, okay? And the purchaser may cancel the contract within 0 days and they've not received the packet yet. Does that mean that the time clock hadn't even started? I mean, I really honestly couldn't tell you what the answer to that is, because there is no case law on it. I don't know how a judge would interpret going outside of this 3 to 7 days. If you put 0 days in there and I mean, is that a waiver? Are they waiving their right to cancel?
Yes.
Or can they cancel before they get the packet in the first place? That's a great question.
Because we're required to get package no matter what.
The other statute, if you go back to one of my, I don't know how to make the slides go backwards, sorry, but the other statute says the seller shall do this. Okay, so can you waive it based upon this statute when you interpret this statute in connection to the other statute that says the seller shall do that? The seller shall get the packet, okay? Can you waive something that the seller is obligated by statute to do? I don't know. There's just no specific language in these statutes that answered that question. And again, what I wouldn't want to do is I wouldn't want to put my client, my customer, in the position of being the guinea pig, okay? Because I would imagine that at some point this will, unless they modify the statute next year and clear up this question, there's going to be some case law that comes out of this, because this comes up in my practice pretty often, using the packet as a way to cancel a contract. Anyway, I saw some hands going up. I'm sorry. Go ahead.
I have 2 questions.
Yes, ma'am.
The 3 days and 7 days, are those physical days or are those business days?
You know, I believe that the definition section says calendar days. So, and it's always, you know, my understanding that it's been calendar days. I would go by calendar days.
Okay, and then it says up to 7 days if extended. So do you have to write in the real estate contract that you're extending it to 7 days?
Yeah, so in your new version of the RVAR paragraph 5 or 6, I can't remember which one it is now, but they've moved it up for some logistical reasons into your top of your contract. It says, because this statute always used to say that this statute started off with a 3-day right of rescission, and then the statute got modified later on to say that purchaser and seller could change the 3 days and extend that, because sometimes people just needed more time to look at the packets. So it is in your contract now, you have a blank there where you can put, and then in parenthetical, it says 3 to 7. Okay. So you put in the number of days between 3 and 7 in that blank. And if you stay within 3 to 7, I can assure you that you are going to comply with the statute. Okay. If you go outside of that 3 to 7 day period, if you do 1 or you do 9, or, you know, because I mean, it could be you have a list, this listing's hot. Okay. And you want as few contingencies in the contract for your buyer as possible. None of us have seen that recently, have we? You know, for the last few years, but you want as few contingencies as possible. The question is can you waive it? Can you waive the statute that says the seller shall provide the packet? There's just no clear definition to it. Just like there is no clear language that says whether you can go less than 3 days or more than 7 days. My preference would be, if you're representing the purchaser, stay within that 3 to 7 day period, because if it comes up, I would really much rather be able to go, well, we did exactly what the statute says, as opposed to going, well, you can interpret the statute this way or interpret it that way. I hope that makes sense. What was your other question? You said you had 2.
You answered both.
Okay, cool. I just can't, you see, if I just keep talking long enough, I'll get around to answering the question.
What if the seller provides the complete package that they received when they moved in, and it says in A2 that whether or not complete, so it would be incomplete as far as the financials, the updated financials.
Yeah.
So
What happens?
yeah, what happens? Can we get out of it? I mean,
You know, it says, in 3, at any time prior to settlement, if the resale certificate is not delivered to the purchaser.
it could be in.
But we're
document.
talking about 1 and 2, where we have a resale certificate that isn't complete because they haven't provided financial information, okay?
Or updated.
Yeah, that's right.
Yeah. Okay, up there, okay, right, it's out of date information, out of date financial information. You know, again, statute isn't really clear because it seems to imply that the homeowners association can go and give this packet of information that doesn't have everything in it. And when they hand you this packet of information that doesn't have everything in it, that's when the 3 to 7 day period starts. And to me, that just doesn't seem logical, because what happens in the situation where the homeowners association provides the packet, your contract has 3 in it, okay? And there's not good updated financial information in it. Your buyer looks at everything and you're okay, I'm good with it. And the 3 days passes, right? And then on day 4, the homeowners association sends you an email that says, oh, sorry, by the way, here's some updated financial information that shows that we used all of our reserves for something, okay?
Right.
What do you do? This just doesn't really, it isn't clear. It isn't clear. A couple things about the statute I wanted to point out to you. In B, it says written notice of cancellation shall be provided to the seller in accordance with the terms of the contract. The purchaser shall have the burden to demonstrate delivery of the notice of cancellation. Okay. That's a term of legal, that's a legal term of art. Okay. We've all heard of burden of proof. Okay. So what they're saying here in the statute is that if this case goes to court and the buyer is responsible to deliver the notice of cancellation because they've looked at the packet, they decided they don't want to buy the property. Okay. You have to prove that you sent the notice of cancellation within that time period, and the burden to demonstrate delivery is on the buyer. So I would tell you, if you have a buyer that is wanting to cancel the contract based upon this act, send that notice. However, not only do you send the notice how your contract says you're going to send it, because some contracts might say, and I can't remember what the RBAR contract says, but it's probably, written notice, probably by first class mail or possibly email or even, hand delivery. I would tell you that if you have a purchaser that's wanting to get out of the contract, not only do what the contract says to do, but send notice every which way you can. Okay. Send it first class mail, if that's what the contract says. Send it by email. If you have to get in the car and hand deliver the notice to the listing agent, do that. Courier pigeon, smoke signals, whatever it takes. Okay. Make sure that you can demonstrate that you delivered the written notice of cancellation. Because if you can't demonstrate that you did that in that time frame that's in the contract, then your purchaser isn't getting out of that purchase. Okay.
Because the purchaser has to.
Yeah, the purchaser has the burden to deliver, to demonstrate delivery. I mean, that's some strong words. The burden to demonstrate delivery. So what that means is, again, it's a legal term of art. When I go into court, okay, I'm going to have to be able to put witnesses on the stand. One of y'all might be a witness in that type of case. And I'm going to have to say, hey, as the agent for the purchaser, I want to talk a moment, with the judge or jury. I want to talk a moment about what you did to deliver the cancellation notice. Let's talk about that for a minute. Tell me how you did it. Okay. And if we did it in a way that doesn't either comply with the contract where, or we did it in a way that I can't demonstrate that delivery of the notice occurred within the time frame, we got a problem. Okay. So just keep in mind that it's something that you may be called upon to talk about later on. So make sure that the darn thing gets there.
And you just use that termination of contract on behalf.
You know, I don't know exactly I can't remember exactly the wording on that termination, but I would make sure that when you go to cancel the contract, that you say that, you know, pursuant to the purchaser's right to cancel the contract in paragraph 5 or 6 of your REA contract, the purchaser is exercising the right to terminate the contract based upon their receipt and review of the homeowners association pact. Whatever, I would make my language in your cancellation track whatever language is in your contract that gives them the right to do that. You know, be very specific about it. So, okay, now here's another thing that's important. D, and highlighted in red. Cancellation shall be without penalty, and the seller shall cause any deposit or escrowed funds to be returned promptly to the purchaser. Okay. I don't know that I would have used the word promptly. If I were the guy writing the statute, I'd have probably put a timeline in it, so many days. But, you know, it's like when you have a contract that says, we're going to do something reasonably. Yeah. There's that's open to interpretation. But again, the cancellation is without penalty, and the seller shall cause the deposit to be returned, which I think answers someone, I can't remember, someone had a question about that earlier, but that answers that question. And again, this goes back to the point I was trying to make earlier, is that since it's without penalty, okay, get that, if you're representing the seller, get that packet, request that packet immediately, okay, so that you get that time frame going. Yeah.
So, some of these associations are really small and very inadequate
Yes.
and stuff, so.
Never run
They
into
may
that problem
not-
before, Glenda.
They
have we?
may not present all of those 30 items and stuff, but if we deliver what they sent,
Mhm.
based on what that just said, is that's maybe an incomplete or not completed, but they sent us, what they sent us, we sent
Yes.
to the agent.
I think that when you send the packet, when the HOA provides you whatever packet they provide you, whether it's complete or not, when you deliver that to the purchaser, then that 3 to 7 day time frame starts, whether the packet is complete or not, according to that statute.
Even if it's not, like, some of these people, I just had a case where the association hadn't, came up to date with these new rules, right? And they said, you know, and so I had a package, but it hadn't changed to come into compliance with the new stuff and stuff. So they gave me that, I had that, I sent that to the agent, she said, well, not, you know, I said, but they're gonna give me an update. I told them, they're gonna give me an update to go along with the cover sheet
Right.
and stuff. So, did it start when I sent what they sent me, or did it start when I got the update, or?
Well, you know, I would, yeah, so I'm being reminded to repeat your question. So,
Okay.
and that was a long question. Okay. So I'm going to try to repeat your question as quickly as possible and summarize it sort of. Is basically what you're saying is going back to the issue of it. The question is this, is what happens if the HOA packet comes to the listing agent and the listing agent provides it to the buyer's agent, okay? And the packet is incomplete, okay? I don't like the way I'm going to reiterate, I don't like the way the statute's written, but the way I read the statute is even if it's incomplete, and they're saying they're going to get us the rest of the stuff later on, okay? If I were representing the buyer, if I were the selling agent, I'd almost be tempted, if you knew that it was incomplete to begin with, okay, I'd almost be tempted to ask the listing agent to not deliver it to me yet.
Right.
Now, if I'm the listing agent, I'm gonna go ahead and deliver it, okay? I'm just telling you that I don't like the statute. I don't like the way it's written. But you know, we got to play the game, and don't, what they say, don't hate the player, hate the game, right? Yes, sir.
Question or thought regarding this. So if we get the incomplete packet
Mhm.
and we're supposed to be delivered within the 3 days, my thought process would be then if we, as the buyer's agent, know that we have an incomplete packet, should we not then possibly turn around, do an addendum to extend that to the 7 days, so we buy the time to have the complete packet to then make the decision?
I think that that is a good idea, yes. The problem, but that's what I would do, okay? I mean, if I were, I think that's a reasonable solution to it. Now, how would it play out if it got into court? I can't tell you because the statute doesn't provide for that. I think there should have been another section in that statute that said, you know, down at the bottom that said, if the packet that is provided is incomplete, then the purchaser may request an addendum to the contract to allow for an extension of time to provide the remainder of the package, okay? But that's just not in there. So it's hard to know how it would play out, but
It would be incumbent then on the buyer's agent to buy that time.
Yeah.
If it's not in there provided for us, then we make the provision.
yeah, I mean, the question really is that are we putting the purchaser in the position of having to cancel a contract that they might not otherwise cancel if they got an incomplete packet and they really wanted to see updated financial information? Okay, they really want to see that. A war story, not here in Virginia, but down in South Carolina. I had a client that was getting ready to buy a condo down in South Carolina. I realize it's completely different law, but at the last minute, okay, they got some updated information about a $4 million roof replacement or something like that.
Oh.
Like literally as they were going to closing. Okay. So now they got out of that contract, but and how they did it, I don't know how we got the attorney down there did it, other than I think everybody just agreed, yeah, that this is right. Okay.
Yeah.
So, you know, but here coming back to the statute. So, I mean, you know, there are examples of that happening. Are we putting the purchaser in the position of having to cancel a contract they might not otherwise cancel just because they didn't get complete information and they know they didn't get complete information? I think a reasonable solution to that is what you suggest, is amend the contract where the buyer and the seller agree that we're going to get the remainder of the financial information or whatever that is incomplete about the packet, okay? And once we get that, then we're going to agree that there's another 3-day period that starts, okay? The statute doesn't provide for it, but I would have to tell you, listen, if I'm the judge sitting on the bench and I got two parties that are entering into a contract between themselves, okay, for an extension of that time, unless the statute specifically says that it's not prohibited, I would probably say, well, they agree to it. What's the problem? Okay. But again, the statute's not clear because it's silent.
But you gotta have the seller will agree to the amendment. Because the seller doesn't agree.
No, I agree with that. I mean, if the seller doesn't agree to amending it, then yeah, I mean, I think your purchaser is put into the position of either making a choice of, I'm not going to buy this property without knowing everything there is to know. I'm not going to buy a property without exercising all my due diligence, or not.
Well, you could also wait and then it still not be available.
Yeah, I
You
mean,
said it's 7 days and then
yeah, I mean,
if
it's
it's not been
Well, this is-
found in the 2 weeks. I mean, maybe it doesn't exist.
Rinse and repeat.
Yeah, I guess you'd have to, but then you're outside of that 7.
yes, ma'am. You have a question?
Yeah, so, there is a condo association that I'm aware of that an attorney is just now really crafting what the rentals that you can, rent the unit that you buy
Mhm.
for a specific period of time. So if I am a buyer and it's really important to me that I can, if I go to Europe for 6 months, I can rent that place out. But that information, this is just an example of something might be incomplete that I don't get. And they are crafting that, and it's crafted after I buy it. What am I bound by? And it could be the age. It could be, that it's if it's over 55, then maybe, I've got a trophy bride I just married or something who's 34. What are you bound by if something is missing bound by the association, do you just get to ignore whatever their rules are that were not there?
Okay,
When
so
you
let's,
sign?
okay, so usually what the question is this, is are you bound by restrictions on the property that might not have been in the packet? Okay. Even if those restrictions aren't included in the packet. I believe that the law on restrictive covenants is pretty clear. It says that a purchaser has constructive notice, even if you don't have actual notice. A buyer of a property has constructive notice of everything that's of record, even if they didn't really know about it. Okay, so like if there's a restrictive covenant that says the short-term rental of property for less than 30 days is prohibited in this neighborhood, okay? And the purchaser didn't know about it because the association didn't provide the restrictive covenants as part of the packet. Your title agent or attorney didn't make your purchaser aware of the fact that there were restrictive covenants, okay? As part of my practice, I've always made sure that, you know, when a purchaser is sitting at the table, that if we go through it, that time, at least, if not before, you know, if there's restrictive covenants, we like people looking at that stuff way in advance. That's the whole purpose of the homeowners association pact to begin with, is to give these disclosures. But if it doesn't happen, we want at the table for them to see that, okay? Because that can become a problem. I think you're still bound by the restrictive covenants. Now, in this statute, which is the next slide, is that if the association, this is interesting, this red part I've highlighted in A and B, a seller providing a resale certificate shall not be liable to the purchaser for any erroneous information provided by the association, okay?
That makes sense.
So, yeah, so that makes sense. The purchaser is not responsible for the association's error, okay? I think where your question, though, is answered is, for purposes of this statute, answered here. It says, a purchaser shall not be liable for any unpaid assessment or fee greater than the amount set forth in the resale certificate, updated resale certificate, or financial update. Then it goes on to say, the association shall, as to the purchaser, be bound by the information provided in the resale certificate or updated resale certificate as to the amount of current assessments, including any approved special or additional assessments and any violation of the governing documents or rules and regulations as of the date of the resale certificate. So what does that mean? How are we going to be able to put this statute, when compared to the basic Virginia common law, which is if the restrictive covenants are a record, even if you didn't know about it, you have constructive knowledge of those restrictive covenants and you're bound by them. I think what the statute is attempting to say is the association itself can't enforce rules or regulations that the association didn't disclose in its packet, okay? The problem with restrictive covenants, though, and what is being missed in the statute, is that usually restrictive covenants, the declaration, provides a private right of action to any homeowner in the subdivision. And certainly, I think common law does that in most cases. So I think what the statute is saying is that if there is a violation of some rule or regulation and the association doesn't disclose it, the association can't bring the lawsuit to enforce it. But that doesn't mean someone else can't. So it's, again, I see the attempt of what they're trying to do, but I unfortunately think it created more questions than it fixed problems. Does that make sense?
Yeah, so the corollary question to that is, does that put the burden, if you are representing the buyer, does that put the burden on the agent to go sort and suss out all of this that may not be in that packet to make sure that their purchaser who, it's really important that they can rent their place, let's say for 6 months or something. And then somebody says, oh, no, you can't. I'm your neighbor. You can't.
So does this put the burden on the agent? Okay, so let me tell you how I think you take care of these types of situations, okay? I'm gonna skip the resale basically, I'm gonna get I'm gonna answer your question here in just a second, but let me get through this part here real quick. What happens if the purchaser closes anyway? Nothing. If the purchaser closes anyway, they close. That's, yeah. What if there's more than one association? You got to get all of them. Here is the statute that talks about the CIC setting the maximum fees for provision of the association. Here's your question, okay? This sort of is your question, but this answers your question. So this was the last thing I had in my presentation, which is my question. My query is this. What if the association is not an association subject to the Property Owners Association Act, and thus the property is not in a common interest community, and thus not subject to the RDA, but or maybe you think at least, that there's some restrictive covenants that my purchaser should know about, and we know they're not going to get a resale certificate or a disclosure packet because none of these things apply, okay? Here's my word of advice to you in answer to your question of, are we responsible for this? Here's what I do. When a real estate agent sends me a purchaser and they're like, hey, we want you to represent this purchaser. They're, even if it's like the settlement agent is, the settlement agency is doing the closing, but they want, the purchaser wants some attorney review of stuff, okay? The first thing I sit down and I ask somebody is, what's important to you about this property? What do you like about this property? What do you not like about the property? But let's talk about what's important, because a lot of times I'll get that question, especially at the lake. I want to know for sure that I can rent this property on a short-term or vacation rental basis, because that's how I'm going to pay for it. Okay. And so then I have to have, I know Lori's over there, I kind of giggle about that too, but as I've heard, that's what we hear. So I'll go through the talk of Bedford County versus Franklin County. Bedford County allows it, Franklin County doesn't, and most, zoning districts. We'll talk about the ordinances. Then I'll talk about restrictive covenants, and I'll say, okay, have you looked to see whether or not there's any restrictive covenants that prevent short-term rental? And they'll say, well, I haven't been provided. How do I get that? And we'll talk about, that some. If they haven't already entered into the contract, if I have a situation where a real estate agent has sent me the purchaser and I found out what's important to the purchaser and they've not yet entered into the contract, and then they'll, usually what happens is I'll go, well, let me suggest some language. Okay. And let me get past this paragraph 28D is your RVAR contract says that, and it's very specific. At settlement, seller will convey the property by general warranty deed, free of all encumbrances, tenancies, and liens, but subject to the restrictive covenants. Okay, so they can't get out just because there's restrictive covenants. So here's my kind of some sample suggested language. Put it in the contract somewhere. The purchaser shall have blank days from the full execution of this contract, what I call the review period, to review any restrictive covenants which burden the property. If the purchaser is dissatisfied with any restrictive covenant which burdens the property, the purchaser may cancel the contract within the review period by giving written notice to the seller that the purchaser is canceling the contract, in which case the contract shall be canceled without penalty and the purchaser shall receive a full refund of the deposit. Or you can make it even more simple in a different situation. The purchaser shall have blank days from the settlement agent's delivery of a copy of the title examination to the purchaser or purchaser's attorney to review any restrictive covenants or other matters of record. And here's the reason why, is because if you use my first suggested sample language and we have so many days from the full execution of the contract, the way that you're going to find the restrictive covenants is probably having the settlement agent get the title exam done. And not every title examiner gets title exams done the same time frame. Yeah, I mean, so I'm part of First Virginia Title Services, which does a lot of title examinations for about 4 or 5 different settlement companies that are even on your banner over there. And, we used to be 3-day turnaround, no less than 3-day turnaround. That was our guarantee. And then the last few years happened and we got to the point, well, we'll get to you in like 7 days. Okay. My point being that if you use my first paragraph there, make sure you know that you're going to get the restrictive covenants within that amount of time. Okay. Another way to do it, if you're not sure about how quickly you can get them from the attorney or the settlement agent or whatever, is just to say that the purchaser shall have so many days from the settlement agent's delivery of a copy of the title examination, which should hopefully include the restrictive covenants, or from the purchaser or the purchaser's attorney to review the restrictive covenants or other matters of record which burden the property. Yes, sir. I think our time is up. So we probably don't have a lot of time for questions and answers, but I'll tell you this much. If you have a question about anything that we've talked about, send me an email. My email is pretty easy. jgilbert on the sheet. Yeah.
Jay Gilbert on the sheet.
J Gilbert on the sheet. Yeah. So if you're not here and you're on the Zoom call, it's jgilbert@gilbertlawva.com. Shoot me an email and I will do my best in a reasonable amount of time, which is open to interpretation, to answer your question. Thank you all. I appreciate you having me.
Are you staying for like 5 more minutes just for a question?